mentioned earlier, that he says he's not averse to the cloud as long as we can do due diligence. But he also says that some of their auditors, especially financial auditors, will not accept cloud services. So, I mean, I think that is true. You really do need to find out from your clients what they'll accept and what they won't. And I think sometimes we get contradictory instructions from different clients, or sometimes even the same client. Um, we spoke a little about privacy. I just wanted to, one of the things that I know comes up on the e-discovery side is with legal holds and, you know, the requirement to keep data, but then also to get rid of the, you're also under regulations to get rid of private data and not retain that data. And I'm wondering if that's something you've dealt with yet, or if that's something that we see sort of out there. I feel like there's a lot of talk trying to get privacy people involved in, you know, data retention questions, and I just don't know if that's something any of you guys have dealt with yet. Tom, maybe you have because of all your healthcare stuff?
I'm sorry, I was
Oh, that's okay.
mute there. Apologies. Run through the question one more time. I want to make
I'm
sure.
sorry, just in terms of you
Yes.
have issues, you know, where you have conflicts between sort of the data you need to keep in terms of litigation and requirements to hold data and, you know, your privacy obligations to not store data that's private. Have you had any conflicts that way?
Oh, certainly. I mean, we do. One of the big things on a pharmaceutical we're doing are doing our trials, and it's got all the data about individuals. And when we have to go to litigation with them, we've got to do a ton of review and redaction. And do we put it up and then redact it, or do we redact it before we put it up in front of outside counsel and/or third-party review vendors? And that happens especially here, and we collect data over on our European sites. It can be very dicey. So we try to stick to a workflow where we identify everything we can that has to do with data privacy, remove it before it goes into the workflow.
So it's sort of basically the data's not leaving your office and going to the law firm.
Well, it depends on, there's a lot of caveats in there.
Okay.
It's all about risk. If it's the European data, we try to keep it in Europe. We don't try to bring it here without redacting it first. If it's, our attorneys at the law firms are the only ones going to look at it, we believe that we're covered with the attorney-client confidentiality for privacy, but it's brought up at every case, every review we go through. We have the same discussion and try to make sure that the attorneys know what's going on, and we talk to the business and make sure that everybody's good to go.
Teresa, do you feel like your privacy people are sort of included in your whole legal process, or is, I've heard at some companies, privacy sort of off on its own?
It's always, as Tom said, it's always a consideration, although I would, in our view, the legal holds process and having to retain information for legal purposes probably gives us an excuse to have some of that customer or employee information around longer than we are required to have it around, especially with the new privacy laws that are coming out. If they're no longer a customer or they're no longer an employee, you now have obligations to disposition that information. If it's subject to a legal hold, it gives us a legal defensible position for even having the information. We treat that type of information, I think, equally with other types of information that we're collecting for any litigation. Again, a lot of the information within the company even is pretty sensitive. We have different parts of the company that are not allowed to see information from other parts of our company because of competitive reasons. And so we're very, we keep our data pretty segregated, and there's a lot of training and education around what transmission people can see versus the generation people and the traders. So we're already pretty sensitized to protecting and keeping information private regardless of whether it's customer or employee related. But from our perspective, I really do think that longer term, we are going to be looking at dispositioning the customer and employee information a lot faster and improving on the procedures and protocols for how we do that than we have typically been in the past.
Interesting. Okay, well, we only have 15 minutes. I wanted to make sure I got to outside counsel guidelines because I think that's a big issue for those of us in law firms. So before we even get to the outside counsel guidelines, what do you guys do you have anything in your RFI pros or your RFP process where you're asking your law firm specific questions about data security or privacy or, I mean, I know we always get asked about e-billing, but, you know, I don't think I've seen too many requests that actually ask us to talk specifically about our security practices. And I'm wondering if that's something you're building in to your proposal process for hiring law firms.
Hey, this is Stefan. You know, it's interesting to hear you say that you don't see it in the RFPs, RFIs that come your direction. I don't historically, you know, haven't seen it in the. We haven't done a formal RFI or RFP for law firms. Typically, we hire them on an as-needed basis. But again, this process I'm going through now to evaluate how do we engage with law firms differently than we have in the past. Doesn't the template engagement letter or RFI and RFI document doesn't include anything particular about information governance or security, which you know, and this again, this one I was looking at recently was coming from one of the top 5 U.S. accounting or accounting/consulting firms. So it doesn't seem like even those firms that are providing these consulting services are thinking about it, but I think we will.
Teresa or
Sorry.
Tom?
Yeah, we always reserve the right and to audit and do a security audit or assessment. We've done, like I said, we did to our top 25, 30 law firms, and anytime a new law firm comes on, it may not be either in the engagement letter, but in the engagement letter we'll have that we have the right to come in and audit, and we will go in and give a standard audit form and go through it and bring it back and have our CISO do a security assessment and see if he sees any glaring flaws, and then we'll come back and ask more questions. But it may not be part of an RFI, but certainly, you know, you've got to be able to respond to them. And I think that's one of the tough things for law firms is because you're going to have such a variety of security assessments coming from so many different places. You want to make sure you have fairly standard answers to be able to provide back and have all your information in one place.
We do every 3 years run an RFP for our law firms, our preferred providers, and certainly there's exceptions and we'll go use some boutique firms for certain matters, but for our top preferred providers, our law firms, we do RFPs, and we do include, again, very high-level questions about security, questions like, do you have a protocol if there is a security breach or a data breach? And they'll answer it yes, no. If you do have a protocol, is it documented? So they're very high-level questions. They don't really get into, oh, well, tell us what types of systems you're using to ensure our data is secured, or the physical security if you're, you know, if we're sending you physical records. But we do touch on it, and you know, the law firms do respond to that. The other questions that we ask are around disposition and retention of the company information at a matter close.
I think that's wonderful. I wish more clients would do that. Is that also something that's in your outside counsel guidelines? I noticed I was just reviewing some outside counsel guidelines in my own firm, and I noticed that some clients actually gave us a retention period where we were required to keep stuff, and some also just say, no, at the end of the matter, you're going to destroy everything.
Mm. Yeah, our guidelines are that we expect you to return the company information provided to you so that you could properly represent the company, not what the law firm would consider their case file or their work
Right.
product. Because I don't know that we could really legally ask for that or get that. I mean, it's the law firm's
Well,
work
you'd
product,
be
and
surprised, actually. I could send you some outside counsel
it's
guidelines.
interesting
There are
because
some
it
people
seems like
saying everything you do for us is our property. So.
well, isn't there something that the firm would need to retain in the event that it would need to, like, defend itself against malpractice or something? It's,
Yes. Well, it doesn't say you can't keep a copy, but it does say they're entitled to
true.
everything. So.
Okay. We do not have that in our outside counsel guidelines. We're just looking for our company records and information returned to us, or some representation that you've destroyed it if we've determined we no longer need it.
Stefan, do you have do you have outside counsel guidelines, sort of boilerplate?
Yeah, we definitely do, and we actually
And do they cover information
they
governance?
covered more generally expectation of privacy and protecting data. We also do have the ability to follow up and audit their practices when it comes to, well, actually, it's a whole host of things, but part of it is actually, privacy or information protection practices, not to the level of IT security. So it's like Tom was saying, it's more general when it comes to, our outside counsel guidelines. So.
Tom, I'm guessing you probably have pretty thorough guidelines.
Yeah,
Not just about billing travel expenses either.
Yeah, no, we've got pretty standard and well thought out, and we update it every year or so, billing guidelines. I've actually engaged a couple of good consultants to help us, craft it and look for other little simple ways to, tweak them. And I guess it can be frustrating because a lot of law firms will either just sign them and send them back and not really know what they're signing. And then others will take a long, hard look at it and say, we won't abide by this. And at the same time,
that was going to be my next question: is how much pushback do you get? Because I think when you get a bunch of law firm people together,
right.
oftentimes we don't even know what the attorneys are signing. The people who are forced to implement these things.
Correct.
You have
we don't get a lot of pushback, but there are, we'll get questions, and whether it's addressed by the in-house counsel, whether it's addressed by the financial people as far as terms and early payment discounts and things like that. Having worked in a law firm, I used to laugh because I still find firms that are fine in waiting 45, 60, 90 days for payment, and other firms are very eager to say, hey, we'll take early payment discounts. We'll take 3% if you pay in 15 days. And some of them actually come after us and say, hey, it's the 14th day. When are you going to pay us? Because some firms realize cash is king.
Mm-hmm.
I think our executive director says that all the time.
Yes.
We have a similar
Teresa,
program
do you have
here
people,
too.
negotiating with you on?
Yeah, I mean, we, as part of the RFP, that's one of the primary reasons we do that and identify preferred firms so that we can establish that strong partnership and then have negotiated rates and then also negotiate things like the early pay. You invoice us and we'll pay you early and we'll get some sort of discount for that. So absolutely we do that.
Coming to the end here, the last thing we have is sort of retention and disposition, which I know we've sort of addressed a little bit during the time. Teresa's quite strong at telling people to destroy their data. Stefan, I'm curious about you. Do you have specific things that you do at the end of a matter?
Actually, most of our transactions with our clients tend to last for a while because they are financing transactions, and we tend to keep clients for a long time. I'd have to go back and take a quick look. I think our guidelines for our counsel are destroy after, I think it's a few years after the end of the matter. in part because as a financial institution, we're supposed to keep records for a set period of time, and oftentimes we go back to our counsel for them. If they choose to destroy records early, and some are actually more proactive in trying to manage basically not only their own costs but data and their client data, it's not a problem for us. If they keep it to the end of the period, that's also fine. There are times where we go back to our law firms and say, hey, we're having trouble putting our hands on something because there's been turnover or something like that. Can you provide us with some of the data or documents that we need in connection with the relationship with the client? But our counsel, actually, there's an incentive for them to follow that because there's a cost associated with it, obviously, both off-site storage and electronic storage.
How would you, have you ever had a situation where you've assumed that outside counsel still has something and they've destroyed it?
Yeah, I have had that, actually, but it was probably at the tail end of a longer period of time. It was probably a 5 to 7 year period where I was going back asking if they had data, and they said, no, we actually gave you notice, 2 years ago, 3 years ago that we were destroying it. I've also had counsel, drop 5, 6, 7 boxes of documents on me saying, didn't hear from the guy who used to be here. We sent him 2 notices, and here's your documents back. So,
Tom, have you ever had anything like that where you were sort of hoping that your law firm still had some data and they didn't anymore?
No, we're kind of adamant about when cases are over, anything on the discovery side, we're kind of, I should say, hawkish in that we make sure we get the data back and then we've got a copy of it. I'm actually sitting here with a 4 terabyte drive trying to bring back up a case that was about 6 years ago, because I'd rather count on us to have it instead of outside counsel. The fact that it might be sitting in one of your guys' servers just eating up backup tape and trying to figure out what to do with it scares me.
We're not happy about it either. I just want you to know.
No, I agree.
It's
I
the partner's fault.
Yeah, I remember. I'm a big believer in a memo I found at a corporate client years ago when we were doing discovery, and it had for their disposition day, they wrote on big pieces of paper, when in doubt, throw it out. I'm a big fan of that.
All right, so we're getting to the end here. I just want to make sure if anyone had any questions, be sure to type it into the Q&A box. Thanks, you guys. I think you all provided really valuable information. A copy of this will be posted, and a recording of the webinar will be on the ILTA website in a few days. Look under the recordings and webinar recordings on iltanet.org. Shortly after the webinar, you will receive a request for you to evaluate today's webinar. These are very important to ILTA and to me, and it will help us to continue to provide quality and timely educational opportunities to our members. I really want to encourage everyone, if you're interested in speaking or if you're interested in helping plan webinars, we're really looking to bring in more people, not just steering committee folks, to help with that. So please feel free to send me an email if you're curious about volunteering on information governance especially. Somebody asked if anyone has an information governance framework to share. Not exactly sure what that means. But I will, David, I will
talking
try
about
to see
the different IGI, the
definitions and stuff for the maturity
definitions
model.
that we had, yeah.
Yeah.
Yeah, if you go to, it's some of these guys.
And there's the law firm, so someone else provided, there's the law firm information governance framework. I think that's in our files on the e-group for information governance, but if not, I will post it again today. Those are great documents. The Law Firm Information Governance Symposium is doing great work and putting out great reports.
And there's
www. Oh, and it's also available at Iron
Initiative.
Mountain. Yeah, and then there's the IG Initiative too. But we have a resources site on the Information Governance Peer Group. You can also look there. So again, thank you everybody for attending. Keep an eye on the ILTA website under the Meetings tab for upcoming webinars and meetings info. We look forward to seeing you on future webinars. And remember, as ILTA's Executive Director Randy Mays always says, tell a friend about ILTA. Thank you again to our wonderful speakers, and thank you all for attending. Have a good day.
Thank you guys for having us.
Bye.
Okay.